Here we are, Lori and I, we are going into the Capitol building. Let's turn around for a second and just see what the Capitol building looks like. And we are going into the Capitol building because we're going to talk about four House bills that are in the Senate right now. And we just have the sinking feeling that the Democrats just want this win, and they're probably not going to vote on any of the amendments that are probably going to be good for us.
They aren't.
And but it's just shameful because we think that the Republican 4 years ago, they probably should have done something about this. Don't you agree?
Yes, I agree totally, because the Dems are going to take
the credit for it. Yes. But here's the good news. If they pass, they're the same laws that are already in process, but there's nobody giving them the teeth or giving the consequences. So we are really just hoping that, next administration, which will start, in January, we can get more bills written for we the people, right?
Thank you, yes.
Okay,
we the people.
We're going in. We're going in.
Justice.
Can we do it this way? We're going in. We're going in. The legal system of compliance in probate court set up by these bills is not what we the people want to ratify. Let's go in and give our testimony.
And we're going to move on to Jody White.
Hi, I'm Jody White from Livonia. I'm a real estate agent, and this is regarding the amendment that didn't get passed with Ms. Johnson. Yesterday, Heather Catella from WXYZ News covered another story about a guardianship case with a Macomb County veteran, Gerald Harton.
Gerald Harton says he survived the horrors of the Vietnam War, only to now feel like he's been captured by the enemy decades later, only this time he says the enemy is Michigan's guardianship system.
This 77-year-old Army veteran survived one of the most brutal battles in Vietnam. Now, decades later, Jerry says he feels like he's a prisoner of the probate court system.
This is not right. This is illegally keeping me. Might as well go to jail.
Jerry's journey into guardianship started last November after he had back surgery and other health complications. His wife, Mary, had power of attorney to make Jerry's medical decisions, but she was hospitalized at the same time, so she could not care for him.
I was in the hospital, and my boy stepped up to be my overseer of the medicine.
So Jerry's son became his guardian, and when a judge approved that petition for guardianship, Jerry was declared legally incapacitated.
The court says I'm not allowed to go to the bank, take any money out, or do anything.
If a judge appoints a guardian and conservator for you, you lose your civil rights, and that means you cannot make your own medical or financial decisions.
I'm kidnapped. I am really kidnapped.
Through their attorney, Jerry's son's family declined to speak to the 7 investigators, but police records show they alleged that Jerry was often the aggressor. According to court records, the allegation that Jerry has dementia has been used to justify the need for guardianship. The doctor's note used to start the court proceedings last fall says he's suffering from likely underlying vascular dementia. Do you think you are mentally deficient?
No. Just no. I remember everything.
This news story and the other 30 stories that Ms. Catella has done on probate court fraud since 2017 are real cases on our fellow neighbors, and these news reports have proven the harm that has been done to so many families over and over again here in Southeast Michigan. Reporter Catella can only do the stories her news producers will permit. And this news outlet is failing to tell the two-part story, because with most guardianship cases, there's always a conservator case attached to it.
I was a millwright by trade, worked 7 days a week for 31 years, and I had everything paid for. My house, swimming pool in the back, a jacuzzi. I was made for my retirement. I'm not allowed to go home.
And then things got messy.
It's just been a nightmare.
Jerry's wife tried fighting the guardianship. His son hired a lawyer, and there are allegations Jerry's wife ignored court orders and refused to pay for Jerry's care. So the judge put Macomb County professional guardian George Heitmanis in charge of Jerry's life. Jerry's guardian eventually transferred him from the hospital to a group home, which he says he's not happy about. And other than one hearing on Zoom in July, Jerry says he has not been allowed to attend his own court hearings.
They always kept me away from court deals. And that's what's made me mad. I said, why do I can't see the judge?
Jerry's written 2 letters to Macomb County Judge Sandra Harrison asking to be heard in court, and his fellow veterans have filled the courtroom to support him, even though he has yet to be able to attend. Instead, his guardian speaks for him.
Mr. Harton has significant neurological issues.
Jerry and his wife both got better. Jerry says he started asking to go back to his own home in Harrison Township.
This is the avenue used by the profession of attorneys who are not licensed with LARA and are exploiting the generational wealth of our neighbors and loved ones. While the Licensing and Regulatory Affairs Department typically oversees professionals to protect the general public, these attorneys are using their legal expertise to take advantage of vulnerable people who don't understand the language used in our probate court system. The citizens that have been coming to the legislators and commissioners, as well as the 2019 Elder Abuse Listening Tour, are in the thousands, not just 30. And the lawyers who have been misusing the system for decades to enrich themselves and fund their personal lifestyles must have legal consequences from today's legislators. The probate system and the 1999 EPIC legislation that was enacted to have guardrails to stop lawyers from exploiting family members and loved ones. It was never set up and voted on 2 decades ago to help the Bar Association in the probate and estate section of their legal organization to use their ill-gotten gains to fund their personal expenses and lifestyles. This is not why the 1999 laws were created. The Attorney General staff has already presented to the legislators time and time again the harm of exploitation being done by these legal professionals. We want consequences for this white-collar criminal behavior. As this group of legislators try to fix the guardianship part of this form of judicial corruption in probate court, you must take a look at the conservator aspect of the criminal enterprise too. We have the scripts of the probate predators. They are using their invoicing procedures to ask the probate judge for authority to charge their egregious hourly fees from $100 up to $500 an hour, while also collecting additional hourly rates from $60 to $100 for their staff members to help them also exploit our loved ones. The line items on their invoices reveal each step that these attorneys take to financially exploit the vulnerable families who are on the superhighway of judicial abuse with no exit ramps. I am requesting that as a new election term of legislators take place for 25 and 26, our representative public functionaries in their roles as House reps and senators continue to research the financial damage that has been done to so many families and to take our calls as we are not picking and choosing which stories will be aired or on the local news channel or written up or featured in the newspaper. We are here representing every single family in Michigan who have been exploited by this predatory practice in probate court.
Thanks for your testimony.
And we want these attorneys to face serious consequences for their predatory actions.
We are going to take up the guardianship bills, which we have heard testimony on over the course of a few different hearings months ago. And so now we're back. This is House Bill 4909 through 4912. Representative Breen, you're welcome to give some remarks.
I know Senator Johnson has been very involved in guardianship. These bills are a very, very, very long time coming. And I know that we have people here who have been wronged by our system. We have people who have had their family members essentially cut out of their lives because of our guardianship system. We've had people lose their homes, their freedoms, all because we have an antiquated system that desperately needs reform. We've had a lot of feedback from the judges, and what you have before you today is the product of that. And I want to be very clear. While we have made quite a bit of progress, there are still many things that need to happen in order to get guardianship in Michigan to where it should be. If we can't get all the changes that we need this term, we're going to come back next term, and we are still going to make some of these changes in order to preserve people's rights. We are requiring a professional guardian to pass a background check, which seems like a no-brainer. We have changes where we outline the order of priority. We have suitability factors being permissive and not prescriptive and allows the court to consider some interpersonal disputes. 4910 regarding guardians ad litem, 4911 which pertains to emergency guardianships, and 4912, one of the bigger changes there is that it requires the court to state on the record why the sale of a ward's property is in the best interest of the ward. We've all heard some horrible stories. We've seen them on the news I urge everybody, please support these bills. They are not perfect by any means, but they are good, and they are absolutely better than what we have. The status quo is not acceptable. I know the Michigan Guardianship Association, we are trying to meet their needs as best we can, and I do wish to continue working with them as well.
I was wondering why the task force, they came up with, I think, 8 basic changes that were supposed to be made, and one of the top ones is that emergency guardianship is highly abused right now, and so they took that on and wanted to tighten that up. But instead, in the bill, they've taken off the only check and balance, which is pretty small, which was that you would at least get to know, that you would have a chance to know that somebody was trying to put you under emergency guardianship. And also, I think it's important to know that these guardians that are referred to often as professional, they have no required courses, no continuing credits. They're not registered, they're not certified, so I really don't think they're professional. But I'm just wondering what would change it from what the Elder Abuse Task Force, which I really appreciate the work they did, 180%, rather than tightening it up, take off the one check and balance, which is the person would know.
I'm not disagreeing with you at all. And I think that maybe there's a possibility of getting an amendment on the floor. Maybe we could do that.
One of the other problems is because they're don't have to have an education, they don't have continuing credits. My daughter wants to cut hair and do nails. She has to take boards, continuing credits. She's registered. When she gets done at Lara, complaints go there. They can collect them. They can see who the bad actors are, right? That was a foundational part of these bills. These people that their families have been victimized, and they've been victimized, and it's chronic and growing. They have no one to complain to because these people are who? Who do you go to? And people keep asking me, and I'm getting the calls. I wish I could help them. I'm an MSW. I'd really like to help them. But all I do is can listen to them. Why would we not have that first, where they have obligations, responsibilities, and can be held accountable?
And actually, that is all that was originally part of this bill. We then had another bill, which is not advancing, unfortunately, right now, to establish the Office of the State Guardian, which was the intent of the Office of the State Guardian was to make a clearinghouse for both professional as well as lay guardians. So people who are taking over for mom and dad and they're running their lives, that would be a resource for them because they need help. It is hard for guardians. And I would also say that a vast majority of guardians are good people trying to do the right thing. They're trying to help take care of folks. And unfortunately, we hear the bad stories. We do. I would like to advance that particular aspect, but I do believe we need to do it outside of these bills in order to make it happen.
That allow people to have a place that they can complain to that's on the record so we can show who the bad actors are and help the good actors to be successful. But we have a growing amount of bad actors and thousands
Thank you, Senator
of
Johnson.
stories. So would it do that? I just want to know. I don't want some secretive thing.
I believe that we can do that with a separate piece of legislation.
It's always a concern to me when a bill before us is flawed and there's an idea that we're going to fix it with another bill coming down the line. As you said, there was a bill that can't get forward. So this is the bill before us with a flaw that I don't know why this stuff isn't fixed. And the number of amendments that ever get accepted on the floor are very minimal. Most of the members think that work gets done in the committee and they're not happy about mending bills that should have been done in committee. So I'm just really happy about this. We're all aware of how horrific this situation is, and we had such hopes that this was going to be a big improvement. It's just frustrating that we're already hearing these right out of the chute, removing provisions that should have been in the reform to go forward, as it sounds like some of us going backwards. So it's just frustrating.
This is progress. This is definitely progress. This is moving forward. It's not everything, but I do believe that these are going to make some very valuable and substantive changes to help eliminate some of the abuses that we have seen in the system. And we have some good judges, and we do have good guardians. And those aren't the ones that we want to crack down on. We like the ones that are following the rules and the guidelines. But because this is a very complicated issue, and to try to put all these things in even just 4 bills is hard. So I do believe that what we have in front of us is a very good step in the right direction. But again, nothing's perfect, but it is a very good step in the right direction.
This is the legislative process, right? We're trying to move forward with something that we think will make an impact for folks, and we can continue to build on it just as we have with many other laws. So. So we'll just really quickly go through the other changes in House Bill 4910. We modified the duties of a GAL by combining what's required under current law and what was proposed in the previous versions of the bill. We removed provisions regarding special limited GALs. We eliminate the restrictions for when a GAL report is or is not admissible. We changed the report deadline to 3 days. We put in back a provision that was inadvertently removed in previous versions that specifies that if a conservator had not been appointed and if the ward's qualified estate was greater than 400% of the federal poverty level, our guardian would have to file a petition for the appointment of a conservator. We require the petition to move legally incapacitated individual from their permanent residence to include circumstances to which that person objects. We also require an inventory of the estate compiled by a conservator to be available for review by the court or an interested person. In House Bill 4911, we allow a court to appoint an emergency guardian without notice if that person complies with Michigan court rules and if the petition clearly shows that an emergency exists. And emergency is defined in the bill already as likely to result in substantial harm to the person's physical health, safety, and welfare, and if there is no other person to act. And in House Bill 4912. The changes we made prohibit a court from appointing a temporary guardian unless the petitioner complies with provisions regarding the appointment and removal of a guardian and complies with court rules. And lastly, we require a court to state on the record why a sale of a ward's property is in the best interest of the ward. So again, these changes were made through a lot of conversation with a lot of different stakeholders. And I know that there are still some outstanding questions and concerns. I would like to be able to move these bills forward and continue the work.
Madam Chair, on the motion to adopt the S3 version of House Bill 4909, there are 6 yeas, 0 nays. The substitute is adopted. Madam Chair, on the motion to adopt the S3 version of House Bill 4910, there are 6 yeas, 0 nays. The substitute is adopted.
There is an amendment that Senator Johnson would like to offer on the S2 version. Senator Johnson?
Yeah, 4911.
Of 4911.
Why do we have in the law that the task force thought was not near strong enough because of the abuse on immediate emergency guardianship, and instead in a 180-degree turn, it got lobbied out what we do have. So someone who's not a professional can determine that you need emergency care and you're not even entitled to know about it. Why would you strip it further when we already know it's weak, it's abused, and it's wrong, and it fails due process for people to even know that somebody's going to come take them away and everything they have? So it just simply puts back into the weak law that people get notice, and it's not a hard thing. How can you say people shouldn't know? It's amazing to me, really. So I feel a little passionate about this one. You already have people being taken from their houses without being told. You're just legalizing. And I think what you're legalizing is kidnapping.
You care very deeply about this issue, and I'm, again, hopeful that we can continue to have conversations about this. For the purposes of moving this forward, I would ask that we are able to move forward with the version that has been sort of negotiated. But there is a motion to adopt the Johnson amendment to this S2 version of House Bill 4911. Madam Clerk, could you call the roll?
Chair Chang.
No.
Senator Schenck. No. Senator Voino. No. Senator Irwin. No. Senator Santana. Senator Runstead. Yes. Senator Johnson. Yes. Madam Chair, on the motion to adopt the Johnson Amendment number 1 to House Bill 4911 S2, there are 2 yeas, 4 nays. The amendment is not adopted. Madam Chair, on the motion to adopt the S2 version of House Bill 4911, there are 5 yeas, 1 nay. The substitute is adopted. Madam Chair, on the motion to adopt the S2 version of House Bill 4912, there are 4 yeas, 2 nays. The substitute is adopted.
I just want to highlight some of the things that I have gone through, which testify to the fact that the guardianship, the same way as in Killers of the Moon, where the ostrich Indians were surrounded by government officials after they found out they had money through the oil. And they surrounded them, took their families, had everything recorded, and they started killing off family members so that the guardian ended up with the whole wealth of that family's money. And the reason it's so popular today in book clubs across America, because this is happening today, and it doesn't seem to be going away. It doesn't seem to be going away because it's such a profitable thing for criminals that carry a bar card and wear a suit and tie and come into court with the black robe. I saw the worst judge in Oakland County get an award. I was flabbergasted for Judge of the Year. He has the most victims in Oakland County by the Michigan Guardian Association. That association seems to be filled with predators. In fact, the same predators that belong to the Michigan Guardianship Association when they took my mother under guardianship instead of me, which would have been following the law, is right here, 2018. Here is the professional guardian list from Oakland County. John Munger, fired from the AG. Jennifer Carney, fired from the AG. Thomas Brendan Frazier, fired from the AG. John Young, fired from the AG. Right now, in 2024, all those people are still operating in Oakland County, stealing from people. And John Young, whose member, it appears, Elizabeth Drury, is currently sitting on the board with his law firm of the Michigan Guardian Association. Now, I'm an elementary school teacher, but I can add 1 and 1 and figure out the answer. And I expect senators who have some type of social acclamation can figure this out. This is harming the citizens of Michigan, and I have a recorded message from one of the Oakland County judges that says they are preparing for the baby boomers. They have it all set up. If they don't come to court with dementia, they're going to ensure they are through their doctors in a 5-minute exam, and it's similar to the mafia.
You're giving these guardians, attorneys to kidnap and murder our loved ones. That's what you're saying. You're saying, Mrs. Chang, that it is okay for someone to come in and take your mother out without a court order like they were going to do to my father. You're saying that it's okay for a guardian in another state to apply a do not resuscitate order on somebody. And she has no degree. She has no degree. I used to be a dental assistant before this incident happened to my father. I had to be certified. These people are taking over people's entire lives, and you think this is okay? The last thing I have to say is, where is Senator Santana, who accepted an award from the Michigan Guardianship Association? She's been missing the past 2 meetings. And why can't any of you agree to protect our loved ones? You don't want them taking out your loved one out of your house, Senator Bayer. You don't want them putting a do not resuscitate order or telling you that they're going to set your mother's or father's stuff out to the side of the road in the trash, and you're not going to get any of it, threaten you to go to jail. They know they can get by with this. It's because of people like you that allow them to. And you need to stand up to them today and say, we're going to protect our Michigan families regardless of what it costs. And that could be maybe some friendships, you guys. I don't know. Why is Senator Santana not here, though? That is the biggest question. And why isn't she agreeing to protect our families? She accepted an award from the MGA. It's really alarming.
That I think that the bills that we have before us do move us forward. Is it everything that everyone wants? No.
And so much of this stuff just comes down to empathy. If it hasn't happened to you, I've seen this in Lansing as long as I've been there, that people don't care unless it's happened to them, and it shouldn't have to be. You should be able to look at people and go, it doesn't have to happen to me. If it's wrong, we got to fix it.
What I've done is some research, and I've looked at specifically the 8 things that Attorney General Nessel's task force wanted, right? And, her committee has done an incredible amount of research, right? And what we're finding is these 8 things would really help if we implemented them. Unfortunately, in these bills, 7 of these things are completely not addressed, right? The 8th thing is emergency guardianship. In Wayne County specifically, you have a 2.5 times higher probability, proportionally speaking, of being put under guardianship compared to the population of Wayne County compared to the rest of the state. And so really what this means is that for these communities, making sure we have strong controls over emergency guardianship is incredibly important, right? So today I'm testifying against House Bill 4911. Unfortunately, because amendments like the one that Senator Johnson proposed were struck down today. I personally, as a citizen of Michigan, find that very frustrating. We had Rep. Kelly Breen here just 20 minutes ago saying that she would like an amendment. She'd love to put it out on the floor. Senator Runstead also agreed that amendments would be best served in committee. And we even had the amendment today, right? And so I find it frustrating because we have an opportunity for real change. We have an opportunity to do this in front of this committee today. I know, just like you said, you want to get these bills through. There are parts of these bills that provide positive value that can go to these communities, but simply allowing this gaping hole in emergency guardianships to exist for an unknown period of time until this Senate and this legislator comes back into session is unacceptable, right? You wouldn't leave holes in the state law intentionally, right? And I just don't understand why that's the case here. When amendments were offered, the House chair clearly said that she wants to consider amendments, and yet we're not considering them today. So I find that to be quite frustrating.
I sit before you as a victim while also representing my 80-year-old mother, now a ward of the state, who has vocalized, "Fight for me, be my voice," for the past 2 years. My mother was placed under guardianship on 10/20/23. My 2 siblings were found unsuitable. While my sister served as guardian, me as conservator, the judge found me unsuitable due to me scheduling my own mother a second opinion oral surgeon appointment. Because I kept my own mother from risk undergoing 2 hours of anesthesia at the age of 79 years old, I was found to be unsuitable. Also, because I took my mom on a visit to my house per her request, I was found unsuitable. It does not make any sense at all. Now that my mom is a ward, I schedule her dental appointments while a professional guardian is in place. Makes no sense when Kent County guardians are appointed the dual role as guardian and conservator. Family is always held to a different standard when they're in these roles. Because I continue to fight, press, retain counsel, I have been retaliated against by the courts. Told to schedule visits to see my own mother in my childhood home that I grew up in for 21 years. The guardians, along with my siblings who have yet to be held accountable for their abuse and neglect. Currently, I am in court now, fighting for my mother in proceedings to save her house from being exploited, in which the guardians are trying to set aside the deed, okay? So, again, no stranger should have priority over family. I pray your hearts are convicted today to pass these bills and go back and amend what we need to do.
We list out suitability factors that the judge must consider with regard to appointing a guardian. So we hope that some of those changes will actually help make sure that we address some of your concerns.
I do appreciate that. Yeah. I have a bachelor's degree in healthcare administration, an associate's degree in medical assistant, and I still was found unsuitable. Been in management for 18 years, employed for 28 years, on my own home, 800 credit score. How much suitable do I need to be my mother's guardian?
I want to apologize to you that we've allowed this, because 26 years ago, we knew this was going on. Governor Granholm, the Auditor General, this one, and the recommendations that I can see that were made in here are, I'm not sure going to help you, because maybe you can tell me in the latest one. It used to say that then the judge would have to put in writing why they made that. And we do have one court system and another one that are on partial shutdowns due to COVID, and people aren't allowed to get on, so no one can see what's happening.
Yeah, no, I appreciate that, and we did make sure to preserve that language in the bill around making sure that the judge's reasons for appointing are on the record. So we hear that. We'll remind folks that this is not the end of the process. We'll still consider, some of the concerns that folks have raised. I do believe that these bills are a step forward, and I also do believe that we still have, more work that we can continue to do in future sessions.
Regarding House Bill 4909 through 4912, not wishing to speak in support, Ruth Ann Jaquette, Executive Director, Mid-Michigan Guardianship Services. Not wishing to speak in support, Honorable Curtis Bell, representing the Michigan Probate Judges Association. Not wishing to speak support, Nicole Shannon, Michigan Elder Justice Initiative. Not wishing to speak in support, Mary Albin, representing Michigan Senior Advocates Council. David LaLamia, representing the Area Agencies on Aging Association. Not wishing to speak in support, Alexander Morris, Michigan Bankers Association. And then not wishing to speak opposed, Matt Miner, representing Oakland County Bar Association.
I actually asked to be on Judiciary 5 years ago because as Secretary of State, people came to me about everything. As you know, they think you're in DC or whatever, but this was one of the top two things that I heard from people over and over. And when I looked into it and found out that the Supreme Court knew about it, tried to fix it, Jennifer Granholm tried to fix it. Our Auditor General here in Michigan actually got an award for finding corruption in this system. So I do appreciate so much the work that the Elder Abuse Task Force has done. I can't tell you how much. Unfortunately, most of it is not in this bill. And the one thing that was probably the most important thing that should come first is these people have to have some place that they register. My gosh, my daughter has to get a license to polish nails. And we're letting people take over people's lives, and we have no place to complain. Zero, zip, none. And I'm so frustrated that we're coming with the cart before the horse. When you don't certify or have a place people complain, like Laura, it is going backwards. The task force knew. They told people, we have a problem with emergency guardianship. People are being grabbed when they shouldn't.
Senator, you need to wrap up.
We've removed that in this bill.
All right.
Yes, I will hurry. And that way we're allowing people to be grabbed. That's what's happening right now. And in Wayne County is the worst place for that in this state. And now it's happening in other counties. So I just don't know why we wouldn't preserve the little bit that we've got. So the Supreme Court 30 years ago actually found that 48 of the 83 counties never require a guardian to file an account with the condition of the ward's estate. Where'd the money go? Where was it? And the FBI raided a real estate company because one of the clerk registers that I know, they had anomalies of all these houses being sold for far less than they were and then sold days or weeks later for far more. The FBI took everything out, and guess what? They were doing that. They were selling
Senator
to the friends and
Johnson.
family, and I want you to know
I appreciate
something.
your passion,
There's no
but we do
law
need to
against
move
it.
on,
Oh,
and
I'm not sure
you will
do,
continue.
Even though I adore you, but as
you.
a chairperson, I just want to say, we're not doing this in the right order. We have been working on this for over 30 years.
Senator Johnson, we have to move on.
We'll catch it next time. We'll get it next year. Why do we wait till next year? Why don't
Senator Johnson, we're going to move on. Again, I appreciate your enthusiasm and your passion, but we need to move forward. I'll entertain a motion to report House Bill 4909, the S3, to the floor with recommendation that it pass. Motion made by Senator Bueno. Will the clerk please call the question?
Madam Chair, on the motion to report House Bill 4912 S2, there are 4 yeas, 2 nays. The bill is reported.
Thank you.